Funny enough, I'm here in Tallahassee, waking up early for a deposition tomorrow. The comments on my Glock V series video, it just went live like 2 hours ago, and there are like 1,200 comments in under 2 hours. Clearly, hot subject, love the debate. Some of the takes are a little rough, but I'm glad that everyone's engaged. Now, a smart question that I saw in the comments that actually spurred me to make this video was, James, if a Glock is readily convertible with a switch and readily convertible firearms are considered machine guns under this definition you just read, does that make Glocks machine guns? There's something interesting that I found whenever I was responding to these comments. In the video that I just uploaded, I flashed the federal definition of machine gun, but I read aloud California's language. California's new law defines a machine gun using the readily convertible to a machine gun language. But the federal statute, the NFA, says shoots is designed to shoot or can be readily restored to shoot automatically by a single trigger pull. Different words and an important distinction. So I'm looking at the language from AB 1227, Control F. Section 2, Section 16880 of the Penal Code is amended to read, and we'll skip to C, the term machine gun includes any weapon deemed by the Federal Bureau of Alcohol, Tobacco, and Firearms and Explosives as readily convertible to a machine gun under Chapter 53, commencing with Section 5801 of Title 26 of the United States Code. Now let's jump over to Chapter 53, Title 26 of the U.S. Code, Control F, readily restored. And here you go. Machine gun means any weapon which shoots is designed to shoot or can be readily restored to shoot. It doesn't say readily converted, even though that's what the California statute uses. Restored implies returning a firearm that was once capable of full auto fire to that condition. California's readily converted language broader than the federal definition based on what appears to be an incorrect interpretation of federal law. Now, even though the statute doesn't define it, restored means brought back to a previous state, right? It had to have originally been a machine gun at some point in order to be restored to one, like a decommissioned M14. We'll talk about that in just a second, actually. Ignoring the Glock 18, of course, Glock was never designed to be a machine gun. It was designed and manufactured as a semi-automatic pistol. There's nothing to restore it to. You can only convert it into a machine gun. That's with an additional part, like a so-called Glock switch. But under federal law, the conversion part itself is the machine gun, not the host firearm that was never fully automatic to begin with. And that's why this new language in AB 1127 becomes a problem, because it substitutes readily convertible for readily restored, as I just showed you, and actually dramatically expands what can be classified as a machine gun, potentially including firearms that were never designed to be automatic in the first place. But what does readily restored mean, since it isn't defined in the code? The Ninth Circuit actually defined what readily restored means in a case, United States v. 1 TRW Rifle M14. Kind of a funny caption, right? It's the U.S. versus an M14 rifle. This is known as an in rem case. That's where you have the U.S. Or a lawsuit filed against a piece of property, right? So against one TRW rifle. This 2006 case, it was about an M14 rifle that had been decommissioned and welded back together into semi-auto configuration. The question was whether it still counted as a machine gun under federal law because it could be readily restored to fire automatically. The court found that it did. They said that since the gun was originally designed and used as a machine gun and could be returned to automatic fire with about 2 hours of work using tools and a stick weld, it qualified as readily restored. The key part, they looked at the definition of restored, brought back to a former or original state. In other words, the weapon had once been a machine gun. It could be brought back to that condition quickly and easily, and that's what the definition covers. It doesn't cover a Glock. Glocks were never designed or manufactured as machine guns. There's no former or original state of full auto fire to return it to. There's no restoration, right? A switch or an auto sear can convert one, but the part itself, the part, not the Glock, is what meets the federal definition of machine gun. The switch is the device that enables automatic fire, and therefore it's the part that's regulated. It's the machine gun, the switch, while the Glock is a semi-automatic pistol unless that part's attached. So under the actual statutory language, how the courts have interpreted it, Glocks themselves can't be considered machine guns just because they can be modified, but the conversion devices can. Bottom line, Glock not a machine gun. It's just a gun that can be abused. The switch is the machine gun, and that's the difference between restored and converted. I'm really glad I read these comments. Thank you guys, because this was actually very enlightening for me to be able to find that California law actually doesn't mesh with federal law. Anyways, I'm going to bed. I got to step out tomorrow. Thanks a lot, guys. Take care.